Hi, it's Jessica from Leverage Legal Group. So let's talk about one of the scariest moments for a business owner. You get an email or a letter saying, basically, you're infringing on my copyright and you must cease and desist by a certain deadline. Maybe it's for a logo, a course, a book, a photo, something that you've used for years, maybe, and something that you truly thought that you created yourself. So what do? Are you in trouble? Can they sue you? And how do you defend yourself if you honestly did not copy them? So let's break this down calmly, step by step, so you know exactly how to protect your business and respond strategically. I just had this happen with a client recently. This last year, I ended up defending a client in federal copyright litigation for somebody accusing this client of copyright infringement. This person did not copy the other person's materials at all and had actually never even seen them. But he got sucked into this massive lawsuit with a pretty sizable claim made against him. And it was so upsetting and incredibly disruptive for his life and his business. The good news is I helped him navigate it, and we ended up getting him out of the lawsuit for a very small amount, significant fraction of what the original demand was. And he's not restrained in any way from continuing to use his own content. So there are ways out of this, and hopefully what I'm going to share with you today is going to give you some guidance on how to do that. I want you to know how to respond and how to protect your business strategically, but always involve an experienced copyright lawyer. Don't try to navigate this by yourself, because there are so many landmines that you could trip up trying to have legal conversations with an opposing side. And it could really mess up your position in a case if you do it incorrectly. First of all, don't panic. The first thing you want to do is verify the claim. So take a breath, take a walk, don't respond emotionally. But the very first step is to verify whether the claim is even legitimate. And so here's what I would do as your lawyer. The first thing that we want to do is check whether that person actually owns the work they claim you copied. And the second one is to verify whether their copyright is actually registered with the US Copyright Office. So here's the key. Under US copyright law, you cannot sue for copyright infringement unless your work is registered. So if they don't have a registered copyright yet, they can't sue, at least not until they file and it's approved by the Copyright Office. No registration, no lawsuit. Now, they can still register after the fact, but even if they eventually register, and they can still file a lawsuit at that point. But at that point, they won't be eligible for what are called statutory damages or attorney's fees. Statutory damages are damages that are set forth in the Copyright Act that make it easy to recover money damages from somebody if you can prove that they have infringed on your work. Those aren't available if somebody doesn't register their copyright before the infringement happens. And attorney's fees, the cost that somebody has to incur to go after someone for infringement, can also be reimbursed. They can force the infringer to pay those costs and attorney's fees. But again, those are only available if that copyright owner registered their copyright prior to the infringement. So if they didn't do that, the only thing they have available to them is actual damages and your profits if you made some profits off of that copyrighted material. So what that means is they have to prove exactly how you hurt them financially or how much money you made from that copyrighted material. So it makes it a little bit harder for them to prove their case, and they're not going to be able to force you to pay their legal fees, which is a really big distinction between a lawsuit involving a timely registered copyright and one that was registered just to pursue the litigation. So that's all good news. But if their work is registered, their options and the risk to you go up significantly. So let's talk about what happens if we're doing our verification and we discover that the work is registered, and particularly if the registration predates the creation of your work or the use of that work, they can sue you for infringement. And here's what that means in plain English. They can demand that you stop using the material, which is called an injunction, and a court can order that. And they can seek those statutory damages that I mentioned a few minutes ago, which range somewhere between $700 and $30,000 per work, or up to $150,000 per work if they claim your infringement was willful. And willful means either that you knew that you were infringing and using the work without authorization or copying it or some portion of it, Or you should have known, meaning if you had done a little bit of due diligence, it would have been obvious to you. You would have discovered that. And so that's a pretty big range. And you do face those risks if they registered their copyright in a timely way. And as I mentioned before, if they registered it in a timely way, they can also ask the court to force you to pay their attorney's fees and court costs and having to go after you. And those are real risks that you might face in that type of litigation. So if they can prove that your use was willful, for example, say they contacted you and you ignored them and you kept using the material, that would be willful infringement. And the court has the power to increase the damages dramatically, basically as a punishment for having used the work without authorization. So the best thing you can do once you receive that notice from the other side, stop using the disputed content immediately until it's resolved. Take it down. Even it may be temporary, you may be able to use it again in the future, but taking it down immediately shows good faith and it prevents the situation from escalating and it prevents you from facing a claim of intentional infringement. So let's talk then about what your possible defenses are if this kind of claim is brought against you. So here's we're going to shift from reaction to strategy. Even if their work is registered, that does not automatically mean that they are going to win. They're going to have to prove two critical elements. They're going to first have to prove that you actually had access to their work before you created yours. Because if you didn't ever see it, how could you possibly have copied it? And they're also going to have to prove that your work is substantially similar, that's a term of art, to theirs in protected expression. So again, the plaintiff has to prove access and substantial similarity. So if you created your work independently, even if it's coincidentally similar, that's called independent creation and it's a complete defense to infringement. So as your lawyer, I'd start by building your timeline. I would gather drafts of the creation process, file metadata, emails, cloud timestamps, anything that shows that you created your work, evidence showing that you never saw or had access to their work, that's incredibly important, and proof that any similarities are based on ideas, facts, or standard design elements, maybe industry buzzwords, descriptive words or phrases. Those are things that copyright law does not protect. So if you can prove the work is an independent creation, that's going to be a full defense and you can defeat the claim, even if their registration is valid. Now, what do you do if their work is not registered? So if on the other side, they don't have a registered copyright, as I mentioned before, they cannot yet file a lawsuit, either for an injunction or for any type of money damages. They could still register and sue later, but they'll be limited to having to prove actual damages and your profits, and they'll have to pay their own legal fees. So while it's still serious, the financial risk to you is much lower. That said, they can still send a cease and desist letter. They can still use the DMCA, the Digital Millennium Copyright Act, takedown notice remedy that's available, which could at least get your content temporarily removed online. If that happens, your lawyer can file a DMCA counter notice showing that your content is original, which often gets the content restored, especially if they don't take legal action quickly. Number one, I would advise you to immediately stop using the disputed material to limit potential damages. Number two, I would investigate ownership. Is their copyright actually valid? And is their copyright registered? Number three, I would work with my client to build your timeline of creation and evidence of it being an independent creation or independent work. And number four, I would assess the risk and decide on the best approach, whether we're going to respond to the cease and desist, we're going to try to negotiate a settlement, or what the defense strategy should be if they do end up filing a suit. Sometimes we can even negotiate a license to keep using the material legally if that's the easiest business solution. And sometimes that is. Sometimes they just want royalties or some type of flat fee payment for the right to have used that material. And you can often negotiate that without admitting at any point that you copied them. Remember, the key is to not panic, but also to not ignore it if you get this type of notification. Silence can actually be seen as bad faith, especially if they're registered. And I have clients who have received cease and desist letters like a year prior, just ignored it, never did anything about it. And then the other side starts to ramp up and threaten litigation, and they come to me to fix it. But by then, it's very difficult to negotiate a settlement because the fact that we're ignoring them looks really bad and has actually entrenched the potential plaintiff in their position. So never ignore it because it can really make the situation worse and compound the risk for you. How do you prevent this in the future? The best defense is always prevention, obviously. So here's what I always tell founders. Register your own original content early, before publishing it or within 3 months after at the latest. And you can always register it before you've published it. So make sure that as soon as you completed a work of any kind, whether it's taking a picture, creating an illustration, there's so many things that you can copyright. The minute you finish creating a course or a video or a podcast episode or a white paper, architectural drawings, all of these things are protectable by copyright. So the minute you complete the work, get it registered if it's something that you want to be able to own exclusively and you want to be able to prevent somebody from copying you. Also, keep creation records. So as you're creating something, keep all the drafts, all the versions, notes that you have, outlines, any emails that reflect the creation process, and upload any timestamps. Save these things so that you've got proof of this timeline. And then when you're working with designers, freelance writers, vendors, outside service providers, make sure you always use contracts that include work for hire language. And again, this is not something you should try to do yourself. You need to have a good copyright lawyer assist you with this so that you know it's done correctly and that it's enforceable. And periodically, you really need to do what I call an IP audit. And that is to make sure that your business owns and properly either creates by itself and registers or licenses anything that you are using in your business so that you're not at risk for these types of infringement claims. And in today's world, with the increased proliferation of AI, an AI audit is a vital part of that IP audit because we need to make sure that you aren't at risk for losing your rights by using AI and that you're also not at risk of infringing on somebody else because of using outputs that came out of AI. So this is really important to include that in any IP audit. And let me just make it clear, an IP and an AI audit are not reserved just for big companies. Even if you're a solo business or a small business, these are things that need to happen. And they're not overly complicated or expensive, but they could make the difference between you facing a type of claim like this in the future or not. So if you've been accused of copyright infringement, as I said, don't panic, but also don't go it alone. I can help you assess the risk, analyze the claim, and build your defense or response strategically so that you protect your business and your reputation. And if you haven't registered your copyrights, now is the time to do it before something like this happens. So reach out to me, let's have a call, and let me help you either schedule your IP and AI audit or help you get your copyrights registered. Let's protect your business and protect your peace of mind. I want to make sure your business is protected on both sides, whether you're enforcing your rights or defending them.